following the Supreme Court decision that was handed down on June 29th, 2 days ago, as we're speaking, in two simultaneous cases. This was Students for Fair Admissions Incorporated versus President and Fellows of Harvard College, and Students for Fair Admissions versus University of North Carolina et al. So the majority opinion was written by Justice Roberts and begins, in these cases, we consider whether the admission systems used by Harvard College and the University of North Carolina, two of the oldest institutions of higher learning in the United States, are lawful under the Equal Protection Clause of the 14th Amendment. There will be no spoilers here when I say that the majority opinion, which was 6-3, was that no, they are not. And I will say that Justice Jackson recused herself from the Harvard part of the case because she herself had been on the board. I can't remember exactly the title, but she had been involved enough in Harvard's governance that she did not feel that she could dispassionately be part of that case. But there were, interestingly, 6 opinions written in this case. There was the majority opinion by Roberts, which was joined by the other five justices who voted with him. That was Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. And then this is just in the order of the 200 and something page document with everything. It's got a summary at the top. Then you've got the Roberts majority opinion. Then you've got Thomas concurring in an opinion, Gorsuch concurring, joined by Thomas, Kavanaugh concurring, and then Sotomayor dissenting, as joined by Kagan and Jackson, and then Jackson dissenting, even though she had recused herself from the Harvard part. And so, a lot of voices, and I will just, so that it's clear what I feel like I know and what I don't know, I read the summary, the so-called syllabus, and I read/skimmed both the Roberts majority opinion, the concurring opinion by Thomas, and the dissenting opinion by Sotomayor. I did not look at Gorsuch, Kavanaugh, or Jackson. So it's fascinating. And I will, maybe I will lead because I've said this before, although I'm not sure. No, actually, I'm gonna save for the end sort of where I think where I've been and where I am now on affirmative action. Not having had my position changed, although having had it been much more informed by doing this bit of reading. Let's just go a little bit of history back, both on a couple of prime issues here. This history is borrowed from the majority opinion by Roberts, again, which came down 2 days ago on June 29th. The 14th Amendment. Right? In the wake of the Civil War, the 14th Amendment, Congress proposes and ratifies it, which specifies that, quote, no state shall deny any person the equal protection of the laws. Let me just have a little asterisk here. In Sotomayor's dissent, in her dissenting opinion, she points out that simultaneous with the passing of the 14th Amendment, Congress enacted a number of race-conscious laws to fulfill the amendment's promise of equality, leaving no doubt that the Equal Protection Clause permits consideration of race to achieve its goal. So not the level of Bill of Rights, of amendments, but that there were simultaneous things that happened at the same level, at the same time as the 14th Amendment. And she and those who concur with her are using that to support the idea of race-based, of using race as one of the factors in applications at, in this case, Harvard and UNC. Later, a few decades later, Plessy versus Ferguson in 1896 comes out with separate but equal. This is widely understood, I think universally understood now to have been a shameful decision.
Yes, one of the worst in the courts.
One of the worst in the courts, as at least the two, at least Roberts and Thomas say this in their, these. It's not that anyone is supporting Plessy v. Ferguson, right? But that stood, the separate but equal stuff from Plessy v. Ferguson stood for over 50 years. And then we have in 1954, Brown versus the Board of Education, which said the right to a public education must be made equal to all on equal terms. And then, so that was 1954, Brown v. Board of Education was 1954. Sort of a slightly more niche part of this, because that was all about segregation more generally. In 1957, Justice Frankfurter summarized what he saw as the 4 essential freedoms that constitute academic freedom. This is interesting to me. Quote, "It is the business of a university to provide that atmosphere which is most conducive to speculation, experiment, and creation. It is an atmosphere in which there prevail, quote, the four essential freedoms of a university. To determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study." That's a good list. That's a very good list. And it gave me pause. It made me stop, and I want to continue to spend more time on those four freedoms that Justice Frankfurter declared as the four essential freedoms of a university. Again, once more, who may teach, what may be taught, how it shall be taught, and who may be admitted to study. Okay. Some number of years later, in 1978, this is coming. I'm getting this history mostly from the summary of the 2023 decision that just got handed down. In Bakke, I think is how it's pronounced. I'm maybe butchering that. Regents of the University of California versus Alan Bakke, decided in 1978, which was Bakke was a former Marine and I think an engineer who had applied to the UC Davis Medical School 2 years running. He was a white guy. And he had not gotten in, and some applicants who were not white, who came in with lower scores and lower GPAs, I believe, had gotten in. And so this got all the way to the Supreme Court. And it turned out that UC Davis Medical School had an explicit quota. 16 out of every 100 applicants. 16 out of every 100 seats were set aside for what was then called minority students. And that was found in University of California Regents versus Bakke to violate the rights of white applicants. Policy was struck down, and Bakke was ordered admitted to UC Medical School. That was a deeply fraught decision. That was 1978. There were 6 different opinions written by 9 justices. There are a lot of opinions written in this case this week as well, but not quite as many. But Justice Powell's opinion back in that 1978 case, writing for himself alone, became a touchstone for race-conscious admissions policies. Powell did not find compelling 3 of the 4 claims of benefit from racially motivated admissions policies, but he did find one compelling. He found one of the 4 reasons that the UC regents had put forward as compelling, which is that educational benefits flow from a racially diverse student body. Once again, educational benefits flow from a racially diverse student body. And furthermore, he wrote that such an interest is, quote, a constitutionally permissible goal for an institution of higher education. And furthermore, as Justice Frankfurter had already said, such institutions can make their own judgments in selection of their student body.
So that is a classic case where a decision is made for population level. It's not.
Yes.
It is that the population of students will be better if they are racially diverse. That is to say that they bring in experience from different backgrounds.
Yes, and actually, as Justice Thomas writes in his concurring opinion, which I'll just say, like I was blown away by his. Of the 3 that I read in some depth, and I did not read any of them completely, but his arguments and also his just the way that he wrote were by far the sort of the most finely tuned and clear with regard to making his points. And he says, I, Justice Thomas, have been looking for the evidence that this is true for all of my career, and I don't find it. I feel at this like emotional level like there is educational benefit to having a racially diverse student body. So I don't think I agree with him at like the emotional level, but he's saying I have been looking for what the purported educational benefits are, and I don't find them. Now I think what's doing a lot of heavy lifting there is the word educational, and education can mean a lot of different things. But can I proceed a little bit and interrupt at any point? And so that Powell's decision in Bakke versus the Regents of the University of California is tricky. It's tough. It's, and lower courts have been trying to figure out if that establishes binding precedent. That was, again, 1978. And then in 2003, we have, again, apologies for pronunciations if I'm getting this wrong, Grutter versus Bollinger, who largely agreed with Powell's opinion that student body diversity is a compelling state interest, but identified a few risks of it, including that race might not be used only as a plus, but also as a negative, that is used to discriminate against certain races, which, of course, was certainly the sort of popular understanding of what was happening at Harvard with regard to East Asian students experiencing lower acceptance rates once Harvard was using race as one of the components of attributes for applicants in deciding who to accept. And in part, to offset these risks, Grutter, and there's disagreement about what this decision in 2003 actually did, but it said at some point they have to end. It has to end. There has to be a standard that you can point to by which you can say, at the point we get there, then it will end. And they estimated in 2003 that 25 years from now, that would be 2028, we should really be there by then. They didn't guarantee, they didn't promise, they presumably hoped it would be earlier, all of that. There wasn't a hard stop, but what they said was any policy, A, can't be used as a negative, and B, has to be finite in its temporal scope, basically. Okay, so the first paragraph of this, I don't know why they call it a syllabus, but like the summary of the document is, Harvard College and the University of North Carolina are two of the oldest institutions of higher learning in the United States. Every year, tens of thousands of students apply to each school. Many fewer are admitted. Both Harvard and UNC employ a highly selective admissions process to make their decisions. Admission to each school can depend on a student's grades, recommendation letters, or extracurricular involvement. It can also depend on their race. The question presented is whether the admission systems used by Harvard College and UNC are lawful under the Equal Protection Clause of the 14th Amendment. This is Roberts' majority opinion. You can show my screen here. He writes, any exception to the Constitution's demand for equal protection, again, as found in the 14th Amendment, must survive a daunting two-step examination known in our cases as strict scrutiny. Under that standard, we ask first whether the racial classification is used to further compelling governmental interests. Second, if so, we ask whether the government's use of race is, quote, narrowly tailored, meaning necessary to achieve that interest. Outside the circumstances of these cases, our precedents have identified only two compelling interests that permit resort to race-based government action. One is remediating specific identified instances of past discrimination that violated the Constitution or a statute. The second is avoiding imminent and serious risks to human safety in prisons, such as a race riot. So those are the exceptions that Roberts, with the majority behind him, specify as the
compelling interests found in prior cases.
Yes.
And that's the second one is fascinating. Hadn't thought of it. But I think what they're saying is if you have to separate people by race to keep a race riot from breaking out, you
can do it.
Yeah, you can do it.
Yeah. Yeah, exactly. So the court has struck down, has basically has said no, Harvard and UNC cannot continue to use race as a factor in admissions. And that ruling was based on several factors, including that Harvard and UNC's admissions policies fail the two criteria of that 2003 Grutter decision that I just mentioned. That is, Grutter specified that race may never be used as a negative, but the First Circuit found that Harvard's consideration of race in applications resulted in fewer Asian students being admitted. Mm-hmm. And I will say, just as a side note, like, it inherently has to, right? Like, if you are saying even in the most bland version of affirmative action that possibly exists, you actually have two identical students and know that's never going to be the case. And there's only one thing that differentiates them, and that is race. And you therefore just use that as one little extra plus and help out the student who is from an historically underrepresented population. You have, of course, de facto made a negative for the student who's from an historically not underrepresented population. And this, again, is a point that Thomas also makes. I had already written my little rant here, and Thomas also makes this point. He says, it inherently does. So therefore, how could you have a policy in place where you say, well, it can be used for a positive, but it can't be used for a negative? Like, well, maybe you're talking about intent, and so you can't intentionally say we really don't want any of those people.
Well,
But in terms of math, by making a choice for one group, you inherently are making a choice against another group.
I will steel man their argument.
Go for it.
I don't believe it.
Great.
But the basic point is you can't say Asians are overrepresented. It counts against you that you're Asian. You can identify a population that's underrepresented, and then it disadvantages the sum total of all of the other things which are not a population.
As opposed to what was, and I did not look into it, but what I understand to have been the case, at least I think at Harvard, where in the sort of the unquantifiable category of like personality, Asian applicants were getting downgraded.
Yeah.
Right. So that is a little different, right? It does
There's
feel
at least
a little
an
bit
argument.
different. Yeah. And then these admissions, and then the second point is these admissions policies also lack a logical endpoint. Outright racial balancing has apparently already been established to be patently unconstitutional, and without an endpoint, we have failed to meet what Grutter established in 2003 as one of the conditions under which effectively affirmative action would be acceptable.
The time point is the
end point, this can't just go on indefinitely point.
But I don't even think that's, yes, the court says that, but yeah. The point is it was never intended to be a permanent remedy, right? The whole idea was to correct a past wrong. And the glaring fact of the present is if we still need it, does that not demonstrate that it doesn't work, right? We have had this policy, and it has not effectively erased the problem. Therefore, not a good policy. And so the problem here is the court is ruling that it's unconstitutional, implying it was always unconstitutional. I guess maybe Roberts' first overriding governmental interest to correct a past wrong is the issue, the one exemption here. But the point is, if it hasn't,
and to correct a past wrong, but also, the idea that there is educational benefit in a racially diverse student body,
right?
That is precedent. There is precedent for that position at the level of the Supreme Court.
Yep. But from my perspective, and I realize you're holding back where you land on all of this, so I don't want to steal your thunder, but the concern, those of us who believe there is a serious historical wrong that is not a simple matter to undo, right?
Yeah.
I think all reasonable people would have to agree with that. That it is desirable to undo that, right? Those of us who believe very strongly in merit, for example, believe that it is unfair to hobble somebody at the starting line, or to put weights on them and then run a race, right? The magic of a merit-based system is most fully realized if people are well equipped to compete in the merit-based system. To the extent that they have been artificially hobbled by past discrimination, there is something to correct. But the glaring problem in the present is it didn't work. It had massive unintended consequences. This is a classic of progressivism resulting in the creation of a noble program that becomes becomes grotesque in the instantiation.
Yeah.
And so therefore, the real question is, well, if this didn't work, the last thing we want to do is have it become a loophole in the 14th Amendment that then becomes an addiction. If the point is
An addiction. Yeah, it's good. Mm-hmm.
so, what we are looking for is a policy that actually stands a chance of working and that does not cause so much carnage, both in terms of disadvantaging people who did nothing wrong and had nothing to do with past racism, and the destruction of a merit-based system, which is frankly the goose that lays the golden eggs. Right? Yes, we should fix it so everybody has access to the merit-based system and the tools in which to compete. But if you want to destroy that system in order that it doesn't embarrass people who've been historically hobbled, then the point is we don't have anything. This is the system that generates the productivity that, yes, is not fairly distributed. But you do not want to destroy that system in an effort to correct one of its harms, which is that it's not fairly distributed. Right? And fairly distributed, I do not mean evenly distributed. Evenly distributed would be wildly unfair, right? You want people to be rewarded in proportion to their contribution to the functioning of that system, right? That's what you want. That's not an even distribution, but it is a fair distribution. And we're looking for that, and we don't have it, but this policy never did it. And so the question is, was the court correct in overturning a policy? Were they overturning it because it hasn't worked? And if so, is that justified on the basis of the time limit that was set by the prior decision?
Again, I don't read it as a time limit.
Yeah.
They do say in 25 years, we think that this should probably be over, but I don't, and there's a little back and forth in between the majority opinion and the dissent. But I do not read it as a time limit. But what is clear, and what the dissent kind of doesn't want to talk about is that there needs to be an end point, that there needs to be a way to end it. There needs to be something that outsiders, that anyone can look at and say, what will success look like? How will we know when we've arrived and therefore can stop this policy? Right? And that is what no one seems to have.